Good afternoon, everyone. Welcome to our largely student and faculty audience in person, our largely alumni audience online. We have 2 full houses. We're so very excited about that. I'd like to thank the newly formed Southwestern chapter of the American Constitutional Society for co-sponsoring today's program and its members for assisting with several important projects related to the event. Members of the ACS Executive Board, including the co-presidents, Alex Gonzalez and Shar Darden, are here today, and I want to give them a round of thanks. And if you're interested in learning more about the organization, or they have some book giveaways they're doing, and if you didn't register, they're right outside the door to give you information. I also want to thank the staff in the Dean's Office, the Administrative Services Office, Communications and Marketing, Information Technology, and Student Affairs for assisting put on today's event. And a little bit about Constitution Day. On September 17th, 1787, the delegates to the Constitutional Convention met for the last time to ratify and sign the document that they had created. Then in 2005, after Congress officially recognized Constitution Day, the U.S. Department of Education announced that any school receiving any sort of federal funds, including student financial aid, needed to put on an educational program each year. So here we are. And we are fortunate and absolutely thrilled to welcome Erwin Chemerinsky to Southwestern. And he's going to be discussing his new book called Worse Than Nothing. Dean Chemerinsky is the Dean and the Jesse H. Chopra Distinguished Professor of Law at the University of California, Berkeley School of Law. Before assuming that position, he was the founding dean of the UC Irvine School of Law. And before that, he was a professor at Duke, at USC, and at DePaul Law School. He has authored 15 books, including leading case books and treatises on constitutional law, criminal procedure, and federal practice, and more than 200 law review articles. He frequently argues appellate cases, including in the US Supreme Court. And during 2022, he is the president of the Association of American Law Schools. I think of Dean Chemerinsky as the GOAT of constitutional law. He is simply the best, not only as a dean and a law professor and a constitutional scholar, he is so generous with his time and his expertise. He comes and he speaks to law students. He speaks to bar associations. He speaks at judicial conferences. He writes op-eds to help educate the public. He takes very important stands on behalf of law students in the context of legal education. And he's absolutely one of the kindest individuals I've met in legal academia. Before he takes the podium, Erwin, I want to congratulate you on being selected to receive the 2022 California Lawyers Association Ronald M. George Public Lawyer of the Year Award. That is just amazing and so well-deserved. Final housekeeping matter, after Dean Chemerinsky gives his remarks, we have microphones so that the in-person audience can ask questions. We've set aside about 15 minutes for that. So if you have a question, come get in queue at one of the mics and maybe you'll get to ask your questions. So without further ado, please give a warm Southwestern welcome to Erwin Chemerinsky.
I wanted to thank Dean Dickerson for the incredibly kind introduction and everyone here for the warm welcome. It's truly an honor and pleasure to be here and to be your Constitution Day speaker. In 1987, Robert Bork was rejected by the largest margin of any Supreme Court nominee in history. There's 58 senators, both Republicans and Democrats against, only 42 senators in favor. Bork was rejected because his originalist approach to constitutional law was thought of as too dangerous. Bork was one of the founders of originalism as an approach to constitutional interpretation. He wrote a famous article in the 1971 Indiana Law Journal, taking the position that the meaning of a constitutional provision should be limited to what was intended when it was adopted. At the time of his confirmation hearing, it was pointed out that this would then mean that there would be no protection of privacy under the Constitution, There'd be no protection for women against sex discrimination. The speech protected under the First Amendment would be very limited. Today, originalism is a philosophy many of the justices on the Supreme Court. 3 justices, Clarence Thomas, Neil Gorsuch, and Amy Coney Barrett, are self-avowed originalists. And all of the conservatives on the court, including Chief Justice John Roberts, Justice Samuel Alito, and Justice Brett Kavanaugh, will often write their opinions in originalist language, or at least join opinions that are written in originalist language. But what I want to suggest to you is that originalism is as dangerous a theory today as it was in 1987. And I want to develop 3 points. First, what I want to talk about is why originalism is undesirable. Second, I want to talk about why originalism is dangerous as a constitutional theory as we regard freedom and equality into the future. And finally, I want to briefly defend an alternative to originalism, the idea of a living constitution. Lest there be any doubt about the premise of my talk that originalism is an ascendancy, we need only look several days at the end of June of 2022, the days between June 23rd and June 27th. On June 23rd, the Supreme Court decided New York State Rifle and Pistol Association versus Bruin. It involved a New York law, initially adopted in 1907, that said in order to have a weapon in public, and especially a concealed weapon, a person needed a permit. In order to get a permit, somebody would have to show cause for having a concealed weapon. The New York court said that this demanded showing that a person had a safety need for having a concealed weapon in public. California had a similar law. The Supreme Court 6-3 declared this unconstitutional. Justice Clarence Thomas wrote for the court, "I think it is the most originalist decision in all of American history." He said, not only is the meaning of the Second Amendment determined by what it was in 1791 when it was adopted, he also said the only kind of gun regulations that would be permissible are those that were historically allowed. Perhaps that's 1791, maybe it's 1868 when the 14th Amendment was adopted. In other words, originalism not only was used to define the scope of the right, but also the extent of government regulation. For those who have had constitutional law, the court rejected the usual levels of scrutiny. I thought the court might have used strict scrutiny if we wanted to protect the right, but instead the court said the only gun regulations that were allowed are those that were historically permitted. The next day, Friday, June 24th, the Supreme Court decided Dobbs versus Jackson Women's Health. As everyone here knows, the Supreme Court overruled Roe versus Wade, the decision 49 years before that held that women have a fundamental right to choose for viability whether to terminate their pregnancies. Justice Samuel Alito wrote the opinion for the court, and he said a right is protected under the Constitution only if it's in its text or part of the original meaning or there's long unbroken tradition. And then the following Monday on June 27th, the Supreme Court decided Kennedy versus Bremerton School District. It involved a high school football coach, Joseph Kennedy, who would go onto the field after games, kneel at the 50-yard line and pray. There were complaints, including by a parent. The parent said that his son and their family were atheists, and the son felt that unless he joined in the prayers, he'd get less playing time. The school asked the coach to stop. He briefly complied, and then he began the practice of going on a 50-yard line after games and delivering a Christian inspirational message that he called a prayer, often joined by players on both teams. When the teacher was suspended and given a poor performance evaluation, he sued, saying this violated his free speech rights and his free exercise of religion. The federal district court, the Federal Court of Appeals, ruled against him, saying that since the early 1960s, the courts have always said that prayer in public schools violates the Establishment Clause. The Supreme Court, in yet another 6-3 decision, ruled in favor of Kennedy, saying it violated his free speech and free exercise of religion rights. The lower courts had relied on a 1971 Supreme Court decision, Lemon versus Kurtzman, which have been taken to define the wall that separates church and state. Justice Alito, writing for the court in Kennedy versus Bremerton Schools, says that Lemon versus Kurtzman has been overruled, that the line in terms of what violates the Constitution is determined entirely by what the framers intended in 1791. So I think you can see from these decisions why I began by talking about how much originalism today in its ascendancy. Well, first, what I want to talk about with regard to originalism is why I regard it as an undesirable form of constitutional interpretation. I see several major problems. One I would call an epistemological problem. The assumption of originalism is that there was a single original meaning that's there to be discovered. But the reality is so many people were involved in drafting the Constitution in 1787, in ratifying it, that it's unlikely there was a single intent to be found. Same thing, we talk about the Bill of Rights. They were drafted by Congress in 1791, ratified by the states, and it's a fiction to say there was a single intent. For those who've had constitutional law, you might have read a case, District of Columbia versus Heller in 2008. It involved the DC ordinance that permitted private possession ownership of handguns. From 1791, when the second was adopted, until 2008, not one federal, state, or local gun regulation had been struck down by the Supreme Court. But in District of Columbia versus Heller, the court 5-4 invalidated this regulation. What's striking about it is Justice Scalia, who wrote for the majority, wrote entirely in an originalist way, talking about what the framers of the Second Amendment meant in 1791. Justice Stevens, in his dissent, wrote in an entirely originalist way, showing what the framers intended was just to have guns for the sake of militia service. When I teach this case, I show my students that there's a strong originalist argument on both sides. In fact, you can make a textual argument on both sides. The Second Amendment says, a well-regulated militia being necessary to the security of the free state, the right of the people to keep and bear arms shall not be infringed. Justice Stevens says, the text tells us about a right to have guns for militia service. The majority says, the first half is the prefatory clause, the latter half is the operative clause. The prefatory clause can't undermine the operative clause. There's an argument both ways, but hardly can a decisive one be made. I saw all of this, the epistemological problem, in a firsthand way here in Los Angeles. At the time, I was professor at USC, and I ran for election to a commission in Los Angeles to rewrite the city charter. And as you may know, a charter in a city in California is much like a constitution. It creates the institutions of government. Here in Los Angeles, the mayor, the city council, the city attorney, the city controller. It can even provide more protection of rights than found in state law with the US Constitution, just not less. And one person was elected from each of the 15 city council districts in Los Angeles. Amazingly, I got elected, and then I got chosen to be the chair of the elected Los Angeles Charter Commission. And we went through a very intense process over 2 years drafting the charter, and the voters approved it in June of 1999. As soon as we finished, issues arose about its interpretation. There was a particular issue that came up right away as to whether somebody who had already served 2 terms in the city council could serve another term under the new charter. And I was called by his lawyers, by the city attorney, and I said, we never thought of that question. Well, a court ultimately ruled in his favor, saying the intent of the voters when they adopted the charter was, this was one sentence in a 100-page document. It was never discussed. The intent was a fiction. Well, in the now years, almost quarter century since this was adopted, there have been many instances where issues come up. Usually they're things we didn't think about in the Charter Commission. But if we did, and I said, oh yeah, we discussed that. If the lawyer agrees with what I'm saying, they say, would you write an affidavit saying that? And if they disagree, they keep calling other commissioners till they find one who will say that. And at least in the years following its adoption, all of us were still alive, and yet we never agreed in terms of what we intended, or more often, we just never thought about the issues being raised. That's, of course, even more so if we talk a document written in 1787 for a very different society. There's another problem with originalism that I would call the abhorrence problem. That if we were really going to follow originalism, it would lead us to abhorrent results. Think of a few cases. Brown versus Board of Education, Loving versus Virginia, Griswold versus Connecticut. They're canonical decisions in constitutional law. None can be justified from an originalist perspective. If there's any case that's the epitome of the Supreme Court at its best, it was Brown versus Board of Education. After Plessy versus Ferguson in 1896, Southern states adopted laws that segregated literally every aspect of Southern life. There was no chance that the Southern legislatures were going to reverse course and end segregation. Southern states had elected judges. They weren't about to do this. The Supreme Court unanimously ruled on May 17th, 1954, that separate but equal has no place in American public education. But the court was explicit that this couldn't be justified on the basis of what we now call originalism. Chief Justice Earl Warren and Brown said explicitly, and I'm quoting, "We cannot set the clock back and just follow the views of the time." In fact, the same Congress that ratified the 14th Amendment also voted to segregate the District of Columbia public schools. So from an originalist perspective, Brown was wrong. Or take Loving versus Virginia, the 1967 decision that said that state laws that prohibit interracial marriage violate the Constitution. At the time the 14th Amendment was adopted, most states in the country had laws that prohibited interracial marriage. California had a law that prohibited interracial marriage till 1948. In 1967, when Loving was decided, there was still 16 states in this country that had laws prohibiting interracial marriage. Virginia vehemently defended its autonomy and its ability to have such a law before the Supreme Court. Again, if one had been originalist, Loving versus Virginia was wrongly decided. Or take Griswold versus Connecticut, the 1965 decision that held that the right to privacy under the liberty of the Due Process Clause affects the right to purchase and use contraceptives. This has long been a target of originalists, saying that this decision was wrong. I would suggest to you that any theory of constitutional interpretation that makes Brown and Loving and Griswold and so many other cases illegitimate is one we should reject. There's a third problem that I would identify with originalism, and I'd call this the modernity problem. The Constitution was written for an agrarian slave society in 1787. It just doesn't make sense to say that we're going to be governed by their views and their intent. Let me go back to Kennedy versus Bremerton schools. The issue is, does a high school football coach in a public school have the First Amendment right to pray on the field? How are we going to find an answer to that by looking back to what the framers thought in 1791? There wasn't football, and there weren't public schools. This came up a decade ago at oral argument in a case called Brown versus Entertainment Merchants. And if you studied First Amendment law, you probably read the case. It involved a California law that prohibited the sale or rental of violent video games to minors under 18. And at the oral argument, Justice Scalia was pressing both sides about the original understanding of the First Amendment. Finally, Justice Alito interjected and said, what Justice Scalia really wants to know is, what did James Madison think about violent video games? There's no way to find answers to today's problems by looking back to what the law was then. Justice Breyer made this point in his dissent in New York State Rifle and Pistol Association versus Bruin. He said, at the time the Second Amendment was adopted, the United States was largely rural. There was no city with the population density that you might find in New York today. So in assessing whether or not a law like New York's is constitutional, we can't just look back to 1791. A final problem that I would identify with originalism, I would call a hypocrisy problem. And that's that the conservative justices who call themselves originalists abandon originalism when it doesn't get to the result they want. Let me give you a couple of examples. One is what I regard as one of the most important and tragically wrong decisions in the last decade, Shelby County versus Holder from 2013. I regard the Voting Rights Act of 1965 as one of the most important laws adopted in my lifetime. If one looks at the low participation, especially of Black individuals, voting in states like Mississippi, Louisiana, Alabama, you see the enormous importance of the Voting Rights Act in the way in which it had a significant effect in enfranchising people who had long been disenfranchised. Section 2 of the Voting Rights Act says that it violates the law for state or local government to have an election practice that has a racially discriminatory effect against minority voters. But Congress knew that just authorizing suits for violation wasn't enough. Do you know the arcade game Whack-A-Mole, where you knock it down in one place and it pops up in another? That's what Congress thought was going on, especially in southern states. They would adopt a law that would limit minority voting participation, only for it to be struck down, and then another one would pop up, and then another one. So Section 5 of the Voting Rights Act says that for jurisdictions that have a history of race discrimination in voting, they would need to get pre-approval, technically called pre-clearance, from the Attorney General at 3-judge federal court. This was enormously successful. There were hundreds of instances of discriminatory laws being blocked by being denied pre-clearance. There were thousands of instances where they didn't even try because they knew they wouldn't get pre-clearance. The law was scheduled to expire, and then in 1981, it was extended for another 25 years. In 2006, Congress considered extending it again. Congress held 16 hearings and created a legislative record that's over 15,000 pages long, documenting the need for the continuation of Section 5 of the Voting Rights Act. There couldn't be a stronger legislative history documenting its necessity. And the vote was overwhelming. The vote in the Senate was 98-0 to extend these provisions of the Voting Rights Act. Can you imagine the Senate today doing anything 98-0? And there were only 3 no votes in the House of Representatives, 33 no votes in the House of Representatives. President George W. Bush signed the extension. But in Shelby County versus Holder, the Supreme Court declared this unconstitutional. It invalidated the provisions that would determine which jurisdictions need preclearance, so no jurisdictions would need to get preclearance. And since 2013, there's been no preclearance requirement. Well, the question I always ask my students when we study Shelby County versus Holder is, what constitutional provision or principle did the court find was violated by sections 4B and 5 of the Voting Rights Act? And you have to read to the very end of Chief Justice Roberts' majority opinion, where he says that the Voting Rights Act preclearance violates the principle of equal state sovereignty, that Congress has to treat all states the same. But then I say to my students, where do you find that in the Constitution? It's a trick question. It's not there, of course. But even more, if one is an originalist, the same Congress that ratified the 14th Amendment also passed the Reconstruction Act that created military rule over southern states and denied them admission to the United States until they ratified the 14th Amendment. That Congress clearly didn't believe in equal state sovereignty. And yet the 5 justices in the majority in Shelby County were the self-avowed originalists, like Anton Scalia or Clarence Thomas. I'll give you another example. It's going to come before the Supreme Court on October 31st of this year. The Supreme Court will have 2 cases about whether college universities can continue to engage in affirmative action. Students for fair admission versus Harvard College, and students for fair admission versus University of North Carolina. In 1978, in Regency versus California versus Bakke. In 2003, in Grutter versus Bollinger. And in 2016, in Fisher versus Texas Austin, the Supreme Court said that college universities have a compelling interest in having a diverse student body. The court said college universities may use race as one factor in admission decisions to benefit minorities. In each of those cases, the conservative justices strongly dissented. I don't think there's anyone today, liberal or conservative, who has doubt about what the Supreme Court's going to do in these 2 cases in October. The Supreme Court's going to overrule Bakke and Grutter and Fisher and hold that affirmative action is impermissible by public universities and by private universities as well. And yet that's impossible to reconcile with the original understanding of the 14th Amendment. The Congress that ratified the 14th Amendment adopted numerous race-conscious programs like the Freedmen's Bureau that today we would call affirmative action. And it's striking to me as I read the opinions of, say, the late Justice Scalia or Justice Thomas opposing affirmative action, that they never mention the original intent. They don't try to justify the decision from an originalist perspective. So those are the reasons that I think that originalism is undesirable. Let me go to my second point and say why I think, and I choose the word intentionally, it's also dangerous. We saw on June 24th that the Supreme Court used it to overrule Roe versus Wade. Rarely in American history has the Supreme Court taken a constitutional right away from people. But that's what the court did in Dobbs versus Jackson Women's Health. In Dobbs, Justice Clarence Thomas wrote a concurring opinion saying, now that we've overruled Roe, we should overrule Griswold versus Connecticut, Lawrence versus Texas, and Obergefell versus Hodges. Now, this isn't my being apocalyptic in making prediction. This is an originalist justice on the court saying, following today's decision, these should be our next steps. Griswold, I've already talked about, as you know, it's the case that said that the Constitution and the liberty of the due process clause protects the right to purchase and use contraceptives. Lawrence versus Texas was the decision in 2003 that said that a state cannot criminally punish private, consensual, adult, same-sex sexual activity. Obergefell versus Hodges in 2015 was the case where the Supreme Court declared unconstitutional laws that prohibited same-sex marriage, finding right to marriage equality for gays and lesbians. Now, Justice Kavanaugh, in a concurring opinion in Dobbs, said none of those precedents are in danger. Justice Alito, in the majority opinion, said other precedents aren't in danger because they don't involve potential life. But I'm not sanguine about this. And the reason is, with an originalist majority on the court, I don't see how Griswold or Lawrence or Obergefell survive. Remember, the majority opinion in Dobbs said that a right is protected under the Constitution only if it's enumerated in the text, or it was part of the original meaning, or there's a long unbroken tradition. And that has to go back to the time the Constitution was written. Because in the Bruin case, a tradition going back to 1907 in New York wasn't enough. In the Dobbs case, a tradition going back to 1973 wasn't enough. Well, if those are the criteria, then Griswold and Lawrence and Obergefell were all wrongly decided. Many states had laws prohibiting the sale, distribution, and use of contraceptives until Griswold in 1965. As recently as 1961, all 50 states in the District of Columbia made it a crime for consenting adults of the same sex to engage in sexual activity. And of course, as recently as 2003, there's no state in this country where gays and lesbians have the right to marry. When the court decided Obergefell versus Hodges in 2015, Chief Justice Roberts, along with Justices Scalia, Thomas, and Alito, vehemently dissented. It's hard to believe that those justices have changed their mind in the last 7 years. Of course, now they've been joined by other originalist justices, such as Gorsuch and Barrett, another conservative like Justice Kavanaugh. So I take Justice Thomas' opinion very seriously in terms of what it's likely to mean for the future. But it extends beyond just these rights. Think of all of the rights that the Supreme Court has come to protect, even though they're not enumerated in the Constitution or weren't part of the original meaning. I mentioned the right to marry in cases like Loving and Obergefell. The court has found the right to procreate to be a fundamental right. Skinner versus Oklahoma in 1942. The court has found the right of parents to custody of their children to be a fundamental right. Stanley versus Illinois in 1972. The court has found the right of parents and families to stay together, including more than just parents, including the extended family. Moore versus Stevie's Cleveland in 1976. The right of parents to control the upbringing of their children has been found a fundamental right. In fact, this goes back a century. Meyer versus Nebraska in 1923. Pierce versus Society of Sisters in 1925. The right of competent adults to refuse even life-saving medical treatment. Kruzan versus Director of Health Services in 1990. And I can go on with other examples. From an originalist perspective, none of these rights can be justified. Now, you might say, is it that there's going to be cases where the court's going to have the occasion to revisit this? And I think the answer is clearly yes. Focus on contraception. Some states are now arguing that the morning after pill acts after conception and therefore is prohibited by state laws outlawing abortion. Some have argued in state legislatures that IUDs act often after conception and they're outlawed by state laws that prohibit abortion. So I do think the court's going to have the occasion to reconsider Griswold. The same lawyer in Texas who is responsible for SB 8 has 2 lawsuits pending that are attempting to provide the vehicle to overrule Obergefell versus Hodges. And even if the Supreme Court doesn't expressly overrule it, I think it's likely the court's going to undermine that right. There's another case to be argued this fall before the Supreme Court, 303 Creator versus Selenis, that involves whether a person based on religious beliefs can refuse to serve same-sex couples. And I have little doubt the Supreme Court's going to come out on that. These are the rights that are in danger. The court follows originalism. But also there's the threat with regard to equal protection. Justice Scalia said on many occasions that the Equal Protection Clause did not apply to prohibit sex discrimination. It only was with regard to race discrimination. And in fact, if you've had constitutional law, you know when the Supreme Court first interpreted the 14th Amendment, in the Slaughterhouse cases in 1873, it said that 14th Amendment Equal Protection Clause was just about race discrimination. And they said it was unthinkable to extend it to anything else. It wasn't until 1971 that the Supreme Court first declared unconstitutional any form of sex discrimination. It was Robert Bork who said that his originalist theory didn't protect women against sex discrimination. But it's now, of course, just that group. I don't see how there'd be any protection with regard to gays and lesbians or people with disabilities or anyone else. So if the court is going to be originalist, it's dangerous in terms of the freedoms, the equality we possess. Well, I wanted to conclude third by talking about why there's an alternative that's much preferable. And it's the idea of a living constitution. Justice Scalia, when he was alive, was fond of saying, the Constitution is dead, dead, dead. Now, I would think just that phrasing would explain what's wrong with originalism. But the idea of a living constitution isn't something new. The Supreme Court throughout history has spoken of the Constitution in that way. It was Chief Justice John Marshall in 1819 in McCulloch versus Maryland who said, quote, "We must never forget that it's a constitution we're expounding. The Constitution had to be adapted and endure for decades to come." Throughout American history, the Supreme Court has obviously always started with the text. It's always relevant to consider if there is an original intent, what it was, but they've also looked to history, to precedent, to modern needs. It was striking this term in reading the decisions and comparing the majority approach and the dissenting approach. Let me go back to New York State Rifle and Pistol Association versus Bruin. The majority approach says the Second Amendment means what it did in 1791, maybe 1868, period. The dissent begins by talking about the problems of gun violence in the United States and how much laws like New York's decrease gun deaths. There was a major case about the environment, West Virginia versus Environmental Protection Agency. The majority limits the ability of the EPA to deal with greenhouse gas emissions from coal-fired plants. The dissent by Justice Kagan begins by talking about the threat that climate change poses to the planet. She talks about all of the ways in which the very existence of human life is imperiled by climate change. There's no acknowledgement of that in the majority. One key reason why non-originalism is so important, why a living constitution is so important, is it does provide the occasion to adapt the Constitution to the circumstances that exist. Now, originalists respond to this by saying that they have a theory that constrains judges. Non-originalists just make it up. What I've tried to suggest today is that originalism doesn't constrain judges any more than non-originalism does. And there's many reasons for that. I've already mentioned that originalism, just abandon originalism, what doesn't get the results they want. But some of it is also what I've talked about in terms of the historical record being so unclear, or having such a variety of statements by those involved, so many different practices, that there's not one intent to be discovered. I mentioned that we saw this in the Second Amendment case, but we see it in so many areas. In the case in this term about the Second Amendment, New York State Rifle and Pistol Association versus Brewing, Justice Breyer includes a part in his dissent where he says, from an originalist perspective, the New York law with regard to concealed weapons is constitutional. Justice Thomas in the majority opinion says, well, some of that history is too early before the Second Amendment. Some is just Texas and it's an outlier, and some is too late. None is Goldilocks, just being right. But of course, originalists can always do this, pick and choose the examples that support the result they want to come to. The late Judge Patricia Wald said that this is a practice that is going to a cocktail party where you look for your friends. She says, an originalist will look through the historical record and find the quotes of the practices that support the result you want to come to, and can always come to the conclusion. Think about it. The cases that I mentioned in my introduction from June of this year, the Supreme Court found expansive Second Amendment rights, no right to abortion in the Constitution, a right of a teacher to pray during a school event. In another case, the government is obligated to subsidize religious education. Unless you believe that the framers of the Constitution and the Republican Party today have the same views, what you see is originalism constraining the justices. They're just justifying the conclusions they want to come to in originalist rhetoric. But beyond that, there'll always be ideological decisions when it comes to the Supreme Court and often the lower courts. No constitutional right is absolute. Even the most fundamental right can be infringed if there's a compelling interest, and sometimes for a lower level of scrutiny. If it's not a fundamental right, there's an important or legitimate interest. But what's a compelling or an important or legitimate interest? The Supreme Court's never articulated criteria for that. And it's inevitably going to be a value choice by the judges. Value neutral judging when it comes to interpreting the Constitution has never been possible. Marbury versus Madison in 1803 wouldn't have been decided that way, but for John Marshall's values and views. From the 1890s to 1936, the Supreme Court struck down over 200 progressive federal, state, and local laws safeguarding workers and consumers because of the conservative ideology of those on the bench. The Warren Court from 1950 to 1969 was the most liberal in history because of the ideology of the justices. One of the things that I think it's important to do going forward is to show that originalism is an emperor with no clothes. It, like all theories, inevitably involves value choices by the justices. When Justice Scalia was alive, he was fond of saying, in response to all these criticisms of originalism, but I have a theory and they don't. And that's why I decided to title my book about this, Worse Than Nothing. Thank you, and I'm glad to take questions. Questions, comments, disagreement? Please, I'm so glad.
Kind of forming it as I go.
That's okay.
So my question, I guess, is when you have an originalist majority court and you come up and you have to have the other side. It seems like the argument that you're bringing is not necessarily one that is a policy argument or something that makes sense. You're more just picking apart the few things that they have used to support their originalist idea. Is that sort of the
it's a great question.
Thing we're in?
And of course, for lawyers who are appearing before the Supreme Court now, and often in front of, especially the conservative judge on federal courts of appeals, or even federal district court, there's the need to make your argument in originalist terms. And sometimes it works. Those of you who have had evidence have studied Crawford versus Washington, the 2004 decision about the Confrontation Clause, where the Supreme Court said that prosecutors cannot use testimonial statements from unavailable witnesses, even if they're reliable. And Justice Scalia writes that opinion. And the lawyers for Crawford did a brilliant job of arguing in terms of the original meaning of the Confrontation Clause. Sometimes you'll try, but it won't work. I argued a case in the Supreme Court a few years ago, Franchise Tax Board versus Hyatt. In 1979, in Nevada versus Hall, the Supreme Court said a state government could be sued in another state's court. My client, Gil Hyatt, was suing the California Franchise Tax Board in Nevada State Court. The jury had awarded him $390 million in damages because of the egregious things that were done to him. Now, it had been reduced a lot in damages along the way. And the Supreme Court granted review on the sole question of whether to overrule Nevada versus Hall. And I knew that in order to win, I needed to get one of the conservatives. I was pretty confident I'd get Ginsburg, Breyer, and Kagan. So I decided to present an originalist argument. And I thought a really good originalist argument. There is nothing in the text of the Constitution about the ability to sue a state in another state's court. And that seems a good place to start if you're arguing to originalists. And there was no discussion at the Constitutional Convention about this, or the state conventions, which seems a good place to start. But then I came up with the idea I could make this a states' rights argument in terms of the 10th Amendment, the ability of a state to protect its citizens from other states. And at the oral argument, I was encouraged by 3 times the attorney for the other side, Seth Waxman, was asked by different justices, where in the Constitution do you find this limit? And finally, the 3rd time he was asked was by Justice Kavanaugh. I said, that's the best I've got. I lost 5-4. The 5 conservative justices, Thomas writing, overruled Nevada versus Hall, Breyer writing for the 4 liberals. So you can make the argument, but that doesn't mean. And then there's places where you can't make an originalist argument. I don't think you could defend Roe versus Wade in originalist terms when the lawyers didn't try. I think you can emphasize stare decisis and precedent and the importance of it. But I think that there were 5 justices determined to overrule Roe, and there were no argument. My puppy could have argued the case, and that case was going to come out 5-4 to overrule Roe versus Wade. So I think as I speak to you as law students who are here, I think you have to do the best you can to make originalist arguments if you're involved in litigation where that matters. And sometimes it'll work and sometimes it won't. And I think the other thing is we also now need to look to other forums if we want to advance rights. And so now the litigation with regard to abortion rights has to go on in state courts under state constitutions and in state legislatures, maybe in city councils, looking to other forums to protect rights. I'll go here and then back and forth.
Can you hear me?
I can hear you fine. Thank you.
I've been following the Students for Fair Admissions versus Harvard case very closely, and I'm very invested in the decision. If you could comment, or if you could say, what is the strongest arguments that respondents can make in defense of affirmative action?
The Supreme Court has said on multiple occasions in the cases that I mentioned that diversity is a compelling government interest. And I'm in my 43rd year as a law professor, and I've taught in classes that are almost all white, and I've taught in classes that are racially diverse. The education for everyone is different when you're talking about affirmative action. Or this semester I'm teaching criminal procedure, and I've just been talking about police stopping for driving while black or driving while brown. And it's very different when there's students in the room who talk about their experience. Just this week, One of my Black students talked about the number of times that he's been stopped by the police for nothing but his race in the car he was driving. Diversity in the classroom matters. And the reality is, given the long history of discrimination and inequities in our educational system today, we're not going to achieve diversity unless there's some form of affirmative action. Someday it won't be necessary, but that then means that those who oppose affirmative action need to say one of two things. Either the diversity doesn't matter in education, or they have to say there's other ways to achieve diversity. And I don't think either of those arguments are tenable. Now, what makes the students for fair admission versus Harvard case different is it's not a constitutional case. The Constitution doesn't apply to Harvard because it's a private university. It's under Title VI of the 1964 Civil Rights Act that says that recipients of federal funds can't discriminate on the basis of race. The Supreme Court has said that the standard under Title VI is the same as the standard on equal protection. I try to make a statutory argument in the Harvard case to appeal to the conservatives, a textualist argument that it doesn't mean the same thing as the Equal Protection Clause. But I don't think the arguments are going to matter. Again, I think I could send my puppy to argue, and I think it's going to be 6-3 it's going to be 6-3 in the North Carolina case, and it's going to be 6-2 in the Harvard case because Justice Jackson's not participating. She's on the Harvard Board of Overseers. I hope I'm wrong in my prediction, but I think what we need to focus on is how can schools continue to achieve diversity once affirmative action is eliminated.
Good afternoon, Professor. Thank you for speaking with us today. My question is, despite the emphasis on the historical lens used by originalists, the logic often comes divorced from historical context. For example, when we look at abortion never being mentioned in the Constitution, but several of the founding fathers wrote how-to guides and considered it a medical commonality. So how do we as law students reconcile these discrepancies with what we see in law versus what we have learned as time goes on, and how do we fight for a better future?
I think that the dissent in Dobbs was right when it said there's no way to understand the majority opinion other than those who are now on the court have an ideology that led them to believe that Roe versus Wade was wrong. That we can see it most simply of if Hillary Clinton had won in 2016, and if she had picked 3 justices to replace Justice Scalia, Kennedy, and Ginsburg, Roe versus Wade wouldn't be overruled. It's about who's on the court and their ideology. Now that has all sorts of implications for all of us. I mean, it's a reminder that presidential elections really matter in terms of who's on the Supreme Court. It's a reminder that law doesn't exist apart from the human beings who are interpreting and applying it, that there's no such thing as mechanical jurisprudence where the law is just there to be mechanically applied. It means that as we go before justices and judges who have that philosophy, we need to think about how to argue in ways that they might be receptive to. And it also means we need to look for other forums to advance rights when we can. That, I mean, lawyers who previously would have gone to federal court, say, with educational equity litigation, have been successful going to state court in doing that. And I think that we need to think of more ways to do that. So all of that is, I think, where we need to go as law students, as lawyers in the future. Thank you.
Hi there. I'm wondering if originalists have an originalist case for originalism, in that did the framers did talk about how they wanted the Constitution to be interpreted, and did they want it in the originalist way?
In the book that I alluded to, there's a chapter called The Incoherence Problem that for time I omitted. And let me address your point directly. There's no indication that the framers of the Constitution meant originalism to be followed. In fact, there's a strong basis for believing the contrary. Remember, the Confederation Congress called a convention to amend the Articles of Confederation. If you look at what they passed in February of 1787, it was to create a convention to amend the Articles of Confederation. And when they gathered, Dickerson was saying, they then decided not to amend the Articles of Confederation, but draft a new constitution. but they all swore each other to secrecy, that they wouldn't talk about what they were doing while they were doing it. And the only official notes were kept by James Madison, and he directed that they not be opened until after his death, in fact, after the death of all of the delegates, because they wanted the Constitution to stand on its own. A law professor at Duke, Jeff Powell, wrote an article in the Harvard Law Review in the mid-1980s titled The Original Understanding of Original Understanding, in which he argues from an originalist perspective, they didn't mean for originalism to be followed, which then has the elegance that if you're an originalist, you have to abandon originalism if you really follow originalism. Now, I think the problem is that the framers of the Constitution didn't think of interpretation like we do today. They very much believed in natural law and formalism in a way that seems so foreign to us today. But there's an even larger incoherence problem. We're talking about how should the courts interpret the Constitution. Article 3 of the Constitution that creates the Supreme Court, the authority for law courts, says nothing about the power of judicial review. It wasn't until Marbury versus Madison in 1803 that it was put there. Now, you might say that the framers intended it all along. That's why they didn't feel the need to specify it. But in England, then and now, no court had the authority to strike down an act of parliament. You would think if they wanted to give the court this major power, they would have said so. Maybe they didn't put it there because they didn't want it. Maybe they didn't put it there because they didn't think of it. But there is a difficulty in trying to say, what did the framers think that courts would do in interpreting the Constitution when the framers didn't say anything about courts interpreting the Constitution at all? And that to me is part of the incoherence problem with regard to originalism.
Good afternoon.
Good afternoon.
Thank you for being here, Professor. So my question is, given the current state of the court, the originalist sway of the court and the conservative, what do you see as the future of impact litigation? A lot of these cases seem to be decided before, a lawyer gets to even argue them, and it doesn't, no matter how well they write the brief or how well they litigate or argue the case, it just seems to be already decided. So yeah, if you can talk about that.
Sure. Let me take your question backwards. It's so important. I mean, what I would say to you as law students, as lawyers is, you never know when your brief and your argument will make a difference. You always have to write the best brief and do the best argument you can in the hope that you'll persuade the court. And sometimes it's a long shot, but whether it's in district court, federal court of appeals, Supreme Court, state court, appellate court, that's what the role of the lawyer is to make the best arguments you can on behalf of your client for the position. In terms of your question, the long term for the court, Clarence Thomas is the oldest justice. He's 74 years old. Samuel Alito is 72. John Roberts is 67. And the three Trump appointees, Gorsuch, Kavanaugh, and Barrett, are all in their 50s. I've long thought that the best predictor of a long lifespan has been confirmed for a seat on the Supreme Court. I mean, Justice Stevens didn't retire till he was 90 years old. Or I can put it to you another way. Amy Coney Barrett was 48 when she was confirmed for the court. If she remains on the court till she's 87, which is the age Justice Ginsburg died, she'll be a justice to the year 2059. So then we get to the what do we do question. Of course, there are proposals to expand the size of the Supreme Court. There's proposals for term limits. I think politically they're unlikely right now. There's trying to look for ways to make arguments for progressive results using conservative methodology. There's looking for other forums to advance rights. I also worry about what it will mean to have a court at a time when the country is so deeply politically polarized to come down solidly on one side. Last September, there was a Gallup poll that had the Supreme Court with its lowest approval ratings in history. 40% approval, 53% disapproval. There was a Gallup poll in early June that had the Supreme Court with 25% public confidence. Marquette University did another poll in early July, and the Supreme Court's approval rating had gone down to 38%, and its disapproval rating was almost at 60%. What will that mean if it continues in the long term? I don't think we can know at this point in time, but it's something we all should be very concerned about.
Thank you for being here, Dean Chemerinsky. It's an honor to have you at Southwestern. Following up on one of my classmates' question, it was, since it does seem like no matter how well your arguments are stated, no matter how optimistic we are, that a lot of these outcomes seem predetermined. What risks do you see to our society with an Amy Coney Barrett on the court till 2059? What, besides court expansion, I was curious where you came down on that in terms of policies we could try. But if you could just kind of talk about the risks and threats that we have to think about as a society to try to maintain. Thank you.
I'll say what I did in response to the prior question. Our country is more politically polarized than it's been since the Civil War and Reconstruction. And there are all sorts of measures of this. And by each and every measure, our country is more ideologically divided than it's been 150 years. The Supreme Court has solidly come down on one side of that line and fairly far to the right on that side of the line. I mean, CNN had a poll in early July that 2/3 of the American people disagreed with overruling Roe versus Wade. What will that mean? The last time there was a major legitimacy crisis for the Supreme Court was in the mid-1930s. And there was then the proposal of court packing, and the justices changed direction. What will happen now? I don't think we can know at this moment in time, which is why I answered the last question by saying we should be concerned.
Maybe in your next book. Thank you.
Good afternoon. Thank you for being here, Professor. We are currently following the Berkeley case. And given such grim predictions, what is your prediction of the ICWA and its possible impact if it's overturned?
Sure. Berkeley involves the Indian Child Welfare Act. And among other things, it gives a preference for Native Americans in adopting Native American children. And the question, and this is one of them, but I think the most important in Berkeley, is whether that violates equal protection. And the United States Court of Appeals for the Fifth Circuit and en banc split evenly. I think it was 8-8 on that question. My pessimistic self says that they're going to look at this as an affirmative action case, and they're going to look at it the same way they're looking at the two university affirmative action cases, and therefore say that a preference on the basis of race is impermissible. My optimistic self says that they'll draw a distinction between Native Americans and race. The University of California has done this. The University of California General Counsel's Office last spring said, we're allowed to give scholarships in the University of California directed for Native American students, even though we can't do it for Black, Latinx, Asian students, because being Native American isn't regarded by the University of California as a race. And if the Supreme Court were to decide that, then the Indian Child Welfare Act is different. Now, maybe the court, even if it sees it a race, would say, given the abhorrent history in this country and the treatment of Native Americans in breaking up Native American families, there's a compelling government interest. Those are the arguments. Given this court, I'm more pessimistic than optimistic, but I hope I'm wrong. And I do think there's a way of distinguishing the affirmative action cases.
Thank you.
Thank you.
Hi, Dean Chemerinsky. Thank you so much for being here.
Thank you.
I must admit that I love constitutional law because of you. My question,
Thank you.
My question relates to this term's cases. So what are your projections as far as future decisions or the judges' difficulties that they will inquire, particularly related to New York State Rifle and Pistol Association versus Bruin, right? Justice Breyer said that judges are not historians, right? So they're ill-equipped to decide cases based on the constitutional text and history and tradition.
As to that example, I think the Supreme Court has opened the door to challenges to every form of gun law by saying the only ones that will be allowed are those that were historically permitted. And I mean, how do you talk about the AR-15 when you're talking about was it historically permitted? I mean, it's an absurd question. In terms of the cases coming this term, which is I think what your question was about, I've already mentioned the affirmative action cases, just mentioned the Burkina Indian Child Welfare Act case. I mentioned the 303 Creative versus Salinas case. Let me tell you the case that I am most worried about that's going to be argued this fall in the Supreme Court. It's a case called Moore versus Harper out of North Carolina. North Carolina is basically a purple state. It went for Obama in 2008, for Romney in 2012, for Trump in 2016, 2020, but always by very close margins. In 2020, Trump beat Biden by 1.64% in North Carolina. The North Carolina legislature is controlled by Republicans, and they drew election districts to give Republicans 11 of 14 congressional districts. Because you can now, through computers, do partisan gerrymandering with amazing precision. In 2018, when there were 13 districts, Republicans and Democrats got each 50% overall of the votes for congressional candidates in North Carolina. But Republicans won 10 of 13 seats because of gerrymandering. The North Carolina Supreme Court found that the gerrymandering for congressional seats violated the North Carolina state constitution and created a commission to redraw the districts to properly represent the politics in the state. Republicans have gone to the Supreme Court, in the cases Moore versus Harper, and said that only the state legislature controls all aspects of elections in the state based on language in Article 1, Section 4 of the Constitution. And therefore, the state courts can't enforce the state constitution, that the state legislature has complete control. Now, this is a concern in itself, but there's another provision, Article 2, Section 1 of the Constitution, that says the state legislature decides how electors are chosen in the state. And those who believe in the independent state legislature theory believe that it's state legislature who allocates electors for the state. Imagine it's 2024. And imagine a state like Wisconsin or Georgia or Arizona that has a Republican legislature, but the voters vote for the Democratic candidate. It's exactly what we saw in 2020. What happens when the Republican legislature says, we're going to give our electors to the Republican, and that decides the election? That's the implications of the independent state legislature theory. I actually believe if that happens, and it's not fanciful to imagine, the country comes apart. So that's what really scares me about Moore versus Harper. I think it's the last question.
Yes, thank you so much for being here. I felt like I was going to constitutional church. I was in the back. Yes.
Separation of church and state.
Sorry. I brought it up. So I'm hearing what you're saying about seeking alternative forums for protecting rights. And I'm wondering about conversations that we've been having about how stare decisis will be taught in law school. And as we're still like learning precedent, to push, what's been done before. But if that's sort of coming apart at the Supreme Court level, then, and we're looking at alternative forums, then what's the future of legal education in terms of how we teach lawyers to protect rights?
I've thought a lot about this. And I will tell you, I've never seen my students as discouraged as they are right now. I think especially Dobbs has taken a real toll with regard to the attitude of students about law and the legal system. So now I can answer your question directly. I think the role of legal education is the same. I still need to teach my students the law because they need to go out and practice on the law. I still need to teach my students how to make the best legal arguments they can, knowing that that's the law. I need to teach my students that courts aren't the only vehicle for social change, that we also need to think about protecting rights through the political process and through other things like state constitutions. And what I need to also convey to my students, and maybe this is the best way to conclude this talk, is that there's still a basis for hope for the future. I can't give my students a false hope, but when I look at the sweep of American history and of world history, there's been tremendous advances in equality and in freedom. Think of race. I mean, there's enormous racial inequities in this country. But think about what it was in 1787 when the Constitution was written, or 1868, or I was born in 1953. At that time, every Southern state still had apartheid. Or think of sex discrimination. Or think of sexual orientation discrimination. It's only 7 years ago that gays and lesbians got the right to marry. And so my hope comes from what Dr. Martin Luther King said of the arc of the moral universe is long and it bends towards justice. And so what I need to convey to my students is The only way that the justice will happen is if they fight for it. It won't happen by itself. Thank you so much for having me today.